Good afternoon. Arul here, and here we are yet with another webinar. And today's webinar topic is on managing and safely terminating employees' medical conditions. So before I begin, good afternoon to all of you all, and thanks a lot. Thanks again for giving us this opportunity to discuss with you through this webinar on how do we manage employees with medical conditions and how do we manage termination of these employees who are not able to work because of medical conditions. Now, if you can hear me or you can and see me, please give me a yes so at least I can move on. Are you able to hear me and see me? Right, if yes, please give me a yes so I will know that you are able to see me. Okay, thanks a lot. And okay, now I know we have covered a few webinars in the recent weeks, and today's webinar, we've done it before as well in the past. For those of you who have missed the previous session, not to worry, we'll cover that again today. So today's webinar is relatively a little bit shorter compared to the last two webinars we have had. So we can spend a little bit more time on Q&A. So let me just, before I begin, I would like to firstly welcome all of you all on board with Malaysia HR Forum. And for those of you all, if you are new, if you are listening today for the very first time, if you are hearing this name called Malaysia HR Forum for the very first time, we have been around for some time as a Facebook platform. We've been around almost 3.5 years or so, but as an organization by itself, we've been around for the last 2 years. Now, have you all recently, just in the last few days, you heard about this, a bank banking in 400 million into account of an employee? Anyone heard this before? Recent news? Yes, did you hear it? There was a bank that banked in about 400 million or 404 million recently into an account of an employee or of a person, right? Now, that person is none other than, our colleague here. So that's why you can see in the news report, banking and, 𝙎𝙊𝘾𝙄𝘼𝙇𝙎, Malaysia HR Forum, that's one of us. Okay, so, we have over 400 members in this HR community. It consists of HR professionals. These are the biggest number. We have got, those people who are not in HR, but they have the inclination or the interest in HR topics. We've got business owners. We've got some of our friends from the authorities who are also part of the group. Now, my advice to all of you listening today is to get as many employees or as many friends of yours into the community so that we can learn together. We share a lot of templates and policies and frameworks, right? There are some guidelines and many other templates, free webinars like what we're having today. Now, do join us and get all your HR members to join this community, right? And just a quick run through about myself. My name is Arul. I think many of you all do know me. We have met, interacted in conferences, events, and other engagements. So I have got over 22 years as of today. In fact, more than 22 years actually. But never mind. I've got more than 21 years engineer by qualification. But my first job is academic, meaning I was attached to a college, and then into training, and then into human resources. And today I'm back into consulting and training. And I'm quite lucky because I have had the opportunity to work for two large organizations, and both these organizations had over 9,000 employees. So when you work in a large organization, you get to experience, many types of challenges and issues, right? Be it, the ones that you can easily resolve, the one that is complex. I've had the chance to work with two unions, and that gives the kind of exposure that we need to have. I know this is not something everybody has an opportunity, but you never know. The organization that you're working with may grow to a much larger organization. Okay, so before I begin my presentation for today, I'm like an old tape recorder. I got to repeat again and again and again, this particular slide. And I would always encourage all HR practitioners to use this copy of the slides, in your presentation. The reason being why, number one, we must always remind ourselves and remind our colleagues and also remind the bosses, right? Compliance is not expensive. We always tend to think that compliance is expensive. So because people think that compliance is expensive, they try to find, shortcuts they're trying to find other methods to manage the issue of compliance. But I can safely tell you this, compliance is not expensive. If you think compliance is expensive, try non-compliance. So in other words, what General Paul McNulty is trying to say here is this. When we follow the law, it is cheaper than not following the law. So let me give you a very simple example that you and we can relate to. Let's say it is now 9:30 in the morning and we want to have a quick wonton mee or teh tarik or quick breakfast, right? So we drive to the nearest favorite kopitiam of ours, and we said 9:30. I think at this hour, if I don't put the car park open, I think it's okay because the Majlis guy, he's probably having his breakfast, right? So what we do, we park the car at the roadside, never put coupon, park illegally, make a quick dash. After 10, 15, 20 minutes, we are back. We realize there's a summon. Now, in this case, what is the cost of compliance? In this case, the cost of compliance is the parking coupon, which is 60 cents, for example. But because we chose not to be compliant, now we may end up having to pay 30 ringgit, 50 ringgit, 60 ringgit, or even more in some town councils, right? So this is an example of where compliance is cheaper than non-compliance. And not only that, now that you need to pay, you got to open up the website, or maybe you want to make a trip to the, to the town council's office, line up, open the app, put in your number, get a QR code or get the OTP, key in, payment, download, print the receipt, keep for reference. Why all this, hoo-ha? If I were to be compliant, I would just need to open up my app. It takes less than a minute, I guess, to activate your parking ticket for the day, and you're done, right? So compliance is expensive. Sorry, compliance is not expensive, right? Non-compliance is expensive. So please share this with your colleagues, your bosses. Sometimes we think that we can save money, we can save costs. Why we need to pay? I think JTK will not come and check on us, right? Or if we do this, I think we can evade the law. Now, again, I would say compliance. If you think compliance is expensive, try non-compliance. And when we are hit with these issues, it's not just about money that goes out of pocket, but employee morale, business disruption. There's a loss of productivity. Now, these are things that we're not able to see. What we see on the surface level is fines, lawsuits, remediation, effect on the brand. But I can tell you, employees will also be demotivated. Now, remember this, it is very easy. It takes a lot of effort and time to build our brand. It takes a lot of effort and time to tell people that we are a company that is highly ethical, highly transparent, and we believe in high ethics and whatnot, etc. But to create a damage to the brand that we build, we spend a lot of effort and time to bring it to where it is. To damage the brand, it takes a few minutes, right? Or it takes a quick short while. So as a summary, I would say this: if you think compliance is expensive, try non-compliance. Now, so today's topic is on managing employees with medical conditions. So we now have roughly about 215 of you all listening today. For this boring topic, I would say, not bad. We have got 216 people. That means you are interested to learn more on how do we manage this, manage the topic of employees with medical conditions. Now, all I could say is this. Our Malaysian regulations, right? If you read case law, if you read, awards from the court and so on, there is an option, right? There is a room for employers to terminate an employee on medical grounds. Now, for the purpose of discussion today, let's not worry so much about the terminology, because on and off we do hear confusion. When should I use the word termination? When should I use the word medical bought out, right? When should I use frustration of contract? Now, these are terminologies. Let's put them aside for today, right? I've always advised, HR practitioners this. Do not worry so much about the terminology. Wrongly using a terminology is not going to cause your case to crash, right? So let's not worry about terminology. Let's focus on the crux of the issue, right? Managing employees' medical conditions. Now, if you have an employee who is not able to work, right? They may be incapacitated due to a medical illness or some form of disability which prevents them from carrying out the job function, right? And Or there could be cases where their condition is so severe that you see very little prospects for them to recover and resume their work, right? And this could be a situation in many of your organizations if you have one. Now, we can bot them out. We can frustrate the contract or terminate them, right? Again, I would say, let's not worry about the terminology. Now, if you want to now remove or terminate these employees with medical conditions, this is what it is expected of you, right? As an employer, if there is a case where you have an employee who can no longer work, what can you do? Can you now remove them? Yes, you can. However, there's a few ground rules that I think you got to take note of. Number one, you are expected to be reasonable, right? You're expected to be reasonable. Number two, you must show that you have exhausted various options and actions, right? You cannot just rely on one particular incident, or you cannot just rely on one particular action you've taken, and then you conclude, oh, I've done whatever I could. Now, that may be insufficient. So, number one, be reasonable. Number two, show that you have taken or you have exhausted various options and actions before terminating the employee. And you also need to make sufficient inquiries. You got to find out, right? You got to find out. Later, I'll be sharing a case where an employee was, terminated because of medical conditions, and the company made a decision merely based on assumptions, right? We cannot base on assumptions, especially when you terminate an employee, right? You must have good reasons. You must have good evidences. You must have proper, valid justification, because later part, when you are brought to the court, if the employee is unhappy, they feel this is unfair, they bring this case up to industrial court, you're going to be there to defend yourself. And you cannot be then saying, oh, I thought, I can, I heard, I think. Now this, you'll be knocked out. So you must make sufficient inquiries, right? Sufficient and necessary inquiries, right? Not just inquire. Inquiry means to find out. It's not just the inquiry, but you must make sufficient and necessary inquiries. And you must also evaluate all surrounding circumstances, right? So let me repeat again. Number one, you must be reasonable. Number two, you must show that you have exhausted various options and actions. Number three, you must make sufficient and necessary inquiries. Number four, you must evaluate all surrounding circumstances, right? Now, if you have done all these four so-called prerequisites, I believe your case would be a much stronger case, or would be a good case. Now, and we must also take note of many factors, right, before we terminate an employee. So these are the factors that you must consider at the back of your mind, right, when you want to terminate. But let me tell you this is not a checklist, right? Now, this is part of our masterclass that we do. We run through this and we discuss many other cases. I always remind participants this is not a checklist. Tick, 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 tick. Okay, since all the ticks are there, I terminate. No. But these are factors for you to consider. Should you make the move? Should you take the next step? Right? It's factors. Number one, for example, the nature of the employee's illness. Number two, the likely of the employee's absence during the recovery period. So the employee is ill and he's going through a recovery period. Now, how long do you expect him to be away? If he's going to be away for a long period of time, for example, 2 years, can you wait for 2 years? Can the business wait for 2 years? Right? Now, the nature of the function of the employee's job. Now, if the employee is ill, what is the impact on the impact on the job, impact on the company, impact on other colleagues? And sometimes some employees, they're recovering, they're okay, then they're absent, they're okay, they're absent. Now, what is the length of various absences and the spaces of good health between them? So okay today, then ill, okay, ill, okay, ill, right? So these are some of the factors that you will need to take note of when we are about to consider to terminate an employee with medical condition. Now, I must repeat again, this is not a process, it is not a checklist. tick, 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 I think it's good to go. These are basically factors for you to consider. And yeah, let me run through this, right? Unfortunately, the what do you call this? The animation is not working. But let me run through this. Again, let me, I would like to share this with you. This is not a process flow, right? This is not a process flow. So what you see here, when you start, right? When you start, there are many types of illnesses, terminal illnesses, chronic illnesses, occupational injury, frequent MCs, and long MCs, right? So what you do is, when the employees are having any of these issues, surely the issues that you have today is one of these, right? In most cases, your biggest concern is frequent MCs and long MCs. So when the employees are having these issues, you wouldn't want to react for every issue. Just because the employee did not come to work last week for 1 week, react. Okay, sending for medical assessment and so on. I would always advise you to wait till the employee exhausts his sick leave and or hospitalization leave. So when they exhaust their sick leave and hospitalization leave, as an employer, I'm concerned. Why is this employee on long sick leave, long hospitalization leave? Why? So I want to find out, right? So what I do, I will send them for medical assessment. And this medical assessment is where you send this employee to the doctor of your choice. You appoint the doctor. My advice would be a specialist and not a GP. Why? Because a specialist is, they are all one step, but they are more competent. They are specialists, right? Perhaps a physician to look into the employee's issues, right? So let's say now I have an employee by the name of 𝙎𝙊𝘾𝙄𝘼𝙇𝙎, right? So 𝙎𝙊𝘾 has exhausted his sick leave or hospitalization leave, or he's been frequent MCs, right? And he has exhausted his MCs or long MCs. Now I'm concerned, as an employer, I'm concerned. So I would say, hey, hi 𝙎𝙊𝘾, what happened to you? How come you have been on sick leave for the last 20 days? And what happened to you? You're not coming to work, on and off sick leave, etc. So now the employee, we as an employer, we are concerned. We would like you to go for medical examination. I want you to go and see Dr. Chong. Dr. Chong is our specialist doctor. Please bring all your medical statement, all your medical reports, and bring all your necessary documentations. Please present to Dr. Chong. Dr. Chong is going to, go through all your reports, and he may even speak to your doctor in, let's say, the other hospital, and to understand better what is your issues. And Dr. Chong will then let us know, his input on your condition, whether you're fit, whether you're not fit. We want to know. We are concerned, right? As a caring employee, we are concerned. And once Dr. Chong has assessed him, and this assessment is not a full-blown medical test where the employee goes through CT scan, MRI. No, this is where the doctor will assess his condition, speak to the other doctor, evaluate his documents, right, and inform the company. Now, if the doctor says that, hey, I think 𝙎𝙊𝘾 is okay, he's perfectly okay, he's fit. Now, then I will ask 𝙎𝙊𝘾, doctor's report says that you're fit to work. So why, can you please explain, why were you absent, right? And of course, 𝙎𝙊𝘾 may have his own issues and argument, etc. Maybe for the first time, I tell 𝙎𝙊𝘾, okay, I can understand where you're coming from, but please, watch out for your attendance, right? If you are genuinely sick, we understand, we will support you. But if you take sick leave in order to avoid work, that is called malingering. If you take sick leave to avoid work, then the company may have to take necessary action against you. Now, up to this point, have you done so, right? If you have not done so, you're not putting the employee on a check and balance. You're not putting him on a very cautious mode. In the case of 𝙎𝙊𝘾, for example, now he will be cautious. Oops, the company is checking on my medical leaves. I got to now be careful, right? Up to this point, you already gained. Now, if you find, and this is where what I will do, if the employee happens to go to many clinics to secure MC, we call this MC shopping. After the medical assessment, I will tell 𝙎𝙊𝘾 this, hi 𝙎𝙊𝘾. Now, starting today or starting tomorrow, we only will accept MC from one clinic. let's say clinic Dr. Jason, right? Or polyclinic Jason. We will not accept MCs from any other places, including GH, right? Unless if you have a follow-up treatment, either in GH or any other specialist hospital, that is a different story. Please continue. But if it's a medical issue that is not related to that, we will only accept MC from polyclinic Jason. Company is paying for it. But if you're not paying for it, you may not be able to assign him to that particular clinic, right? Remember, if you go back to the Employment Act, it says this: an employee shall be examined at the expense of an employer at the employer's chosen medical practitioner. So you choose and you pay, right? I had a question once upon a time, or some time back. Can we ask the employee to go for medical assessment, but we don't want to pay? Then it's going to be hard, right? You can't ask him to pay. If you ask him to pay, he will say, I don't want to go to polyclinic Jason. I don't want to see Dr. So-and-so. I want to see my own doctor because I pay very minimum, right? So you need to take control of this. If you want to put someone on this medical process management, there's a cost that you got to bear, right? Now, so you send them for medical assessment and counseling. If you see the blue arrow, I'm so sorry the animation is not working today, I'm not sure why. But if you see the blue arrow, right? If you see the blue arrow, now, if maybe maybe Siva by now, he says that, oops, I better be careful. Now, he may go back to permanent modified duty or permanent light duty or back to original position, right? I tell you what, just give me a second. Let me just open up another slide. I think it's okay, right? I just open up another slide with the animation. Again? Okay, so yeah, let me just show you the animated page. A second, give me a minute. This is my masterclass slides. Hang on a second, let me just show you them. Just give me a minute. Okay. Right. So I hope you're able to see the funnel now. Are you able to see the funnel? Okay, good. So let me show you the funnel. Okay, so let me show you, this animated slide, let me repeat the funnel again. So what you can see here, these are the issues the employee has: terminal illness, workplace accident, non-occupational workplace injury, frequent MCs, long MCs, others. Others could be, let's say mental health, depression, and so on. So you send them for medical assessment, right? And send them for medical assessment. And maybe after the medical assessment, they may need further observation. They've not fully recovered, right? They need to still rest at home, because once they've exhausted at 14 days or 60 days, right? It's 14 and 60, it is now 74, exhausted, but they still have not recovered. Maybe they got to still rest at home for another 2 months, 3 months, 4 months, right? Or some of them, maybe they have recovered to some extent. They've done good recovery, but not yet fully recovered. So this is where, if you have a modified duty or a light duty, which is temporary, give it to them, right? Now, there could be some cases where the employee has recovered after 60 days, they've recovered. Maybe the employee had a minor accident, he's recovered now. After 60 days, he's recovered. Now, he may be back to his original position. Or what happens in a case where the employee has recovered, but he can no longer go back to his original position. Let's say now, after the accident, a plate was put into his leg, right? And he limps, right? He limps. Now, he can work, but he cannot do the technician job anymore. He cannot climb up the, machine, go under the machine, climb up the chimney, and so on. He can't do that. He can't do anymore physically exerting work. He can't do that. So he may require a light duty or modified duty. If you have it, you give it to him, right? Now, in some companies, some cases, some of you all do have prolonged illness, right? Or in short form, we call it PIL. So prolonged illness leave will be given to employees, right? Once they've exhausted their sick leave. Now, not all companies have prolonged illness. Some of you all do have it, some of you all don't have it. Is it a must to provide prolonged illness? It is not a must, right? Some of you all may be giving it as a benefit to the employee because you're concerned the employee will be on a long period without pay. So in order to supplement their income, you provide prolonged illness leave. What is a prolonged illness leave? A prolonged illness leave is where an employee is not working, he's exhausted his sick leave and hospitalization leave, but he's still paid during the leave. So I know there are many formats, there are many types of prolonged illness leave in terms of duration: 3 months full pay, 3 months half pay, 3 months no pay. It can be 222, it can be 633, it can be 3 and 0 or 3 and 3. So that is really up to you. Is PIL required by the law? Answer is no, right? This is a company's own generous benefit. If you want to have a sample PIL policy, you have it in the forum. One of the members has done it up, shared with us. We did a bit of review, and we have shared this PIL policy in the forum. Have a look at it. Now, so if you have PIL policy, give it to them. In some cases, if your employee qualifies for SOCSO rehab, right? If they qualify for SOCSO rehab, I think SOCSO has got a rehab center in Malacca, and if I'm not mistaken, either Ipoh or Johor, one of these places. If they qualify for it, send them for rehab. Now, once the rehab is done, right, or after prolonged illness leave, maybe they still need more time to recover. They've not recovered yet. There's still more time. If you're okay to give them more time, put them on further observation. Further observation means here, they are not working, they are resting at home, recovering. Or if they have recovered to some extent, but they are not able to resume work. Let's say the technician had a bad accident, right? And after 9 months, he managed to recover fully. Recover, but not 100%. So he can still work, but he can't do the old job, the previous job that he did. So if you have a light duty or modified duty, you give it to him, provide that to him. Now, after this, you send him for another medical assessment, right? And to the same doctor, so that the doctor can see the progress. The first assessment, how was it? The second, the third, and so on. And at the end of the day, right? So I repeat, you see the animation again. At the end of the day, you can see a red bar, a red arrow appearing, and one more line. At the end of the day, he may be back to original position. He's now fully recovered. Or his recovery, that's it. That's the best. He can work, but he cannot resume the same job. So what you can do, provide him modified duty or light duty if you have one. Or you can create one, right? If you can create it. Or he's back to his original position. He's okay, he's perfectly fine. Everything is good and fine to go. Or he cannot resume work. He can't do modified work or light work. Therefore, you may need to frustrate him. Or if he qualifies for SOCSO's bought out, you bought him out. Right? Now, so let me ask you this. From the start to the end, how long do you think it takes? Anyone? From the start to the end, how long would it take? End to end, how long would it take? 3 months, 4 months, 8 months? What do you think? Anyone? How long would it take? What say you? So from end to end, my approach is 1 year. Because why? Remember this always, industrial court always says this. Take a slower approach to terminate an employee, right? Unless major misconduct, breach of contract. Now that is disciplinary, right? That is a different story. If an employee, let's say, was caught stealing, or he was committed and proven of sexual harassment, or maybe cheating the company. These kind of cases, follow a due process, show cause letter, domestic inquiry, terminate him if he's guilty. But when it comes to performance, when it comes to medical issues, always take a slower approach. How slow is slow? That is for you to decide. The court never give an idea what is slow, what is fast, right? Take a slower approach. Now, we know when an employee has a medical issue, recovery is not that quick. Fever, flu, 2-3 days done. Cough, maybe a week or two. But if the employee has some other illnesses, long-term illnesses, recovery is not 1 week, 2 weeks. So I would suggest for you to review, what should be the right time frame end to end. In some cases, it can be a little bit earlier. So for example, let me give you an example. An employee met a very bad accident, and and his condition is so bad, he applied for SOCSO, bought out SOCSO's pension, and he got it within 9 months. Well, that's it. He's 9 months. So there could be some cases that can be a little bit earlier, but if it's not, I would never encourage anyone to rush, right? To rush the process or to rush the whole topic. So this is what I call as the funnel that I created. I don't think you'll find this in any HR book or IR book. It's a funnel I created, based on my experience of terminating many people using this funnel. Now, again, I would like to say this is not a process flow, right? Or I do this in. So I had one of the members of the forum, during the masterclass, she took this whole thing, she did a process flow, right? And I told her this, I will be a little bit hesitant to put this in a process flow. Okay, like this, yes, no, like this. Because why? This is a very subjective topic. It is not an objective topic. This is a very subjective topic which requires you to consider a lot of factors. Now, my question to all of you all is this. When you see this funnel, what do you think I'm trying to do? What do you think I'm trying to do? When you look at this funnel, here, there, arrow, up, down, what do you think I'm trying to do? So let me go back to the first slide I shared just now. Now, let me ask you this, and I want you to say yes or no to me. Be quick to say yes or no. Yeah. So be quick to let me know whether I did it right. Number one, were I reasonable? Yes or no? Anyone? Were I reasonable? Right? Were I reasonable? So far, no one's answering me. Yes, okay, that's good. Did I show that I have exhausted various options and actions? Have I exhausted it? Anyone? Right? Now, did I make sufficient and necessary inquiries? Remember, assessment every 3 months. Ask the doctor. Did I make necessary inquiries and sufficient inquiries? Yes or no? Now, did I evaluate all surrounding circumstances? Yes or no? Now, if you have done all of this, I believe, right? I believe you are on a very strong and solid ground to take the next step, right? So again, not a process flow, but some kind of guidance, some form of funnel to tell you, how should you proceed with this? Now, my question to you is this. How frequent should I do a medical assessment on the employee? How frequent? Now, again, case laws do not suggest how many times. It doesn't suggest. My advice or my design is this. Every 3 months, 1 assessment. So in 1 year, you have 4 assessments. Now, when you have 4 assessments, you have more data point, right? You have more data point to guide you. So you can see over the 4 assessments, is the employee improving, or the progress is stagnant, or his process is, his improvement is really not deteriorating. So which one is it? So the more data point you have, the better it is, right? So my advice, 4 assessment in a year. Each assessment, depending on how you negotiate with your doctor, it can cost you anywhere between, let's say, 300 ringgit to 500 ringgit a month. So you got to select a doctor. Now you may tell me this, wow, you mean I got to spend 300 ringgit a month, or every 3 months, 300 or 500 ringgit? I got to spend so much. Why should I spend so much? Go back to my first slide. If you think compliance is expensive, try non-compliance. If you think doing all this expensive, then don't do it. Terminate employee, without all this without all this approach and see what happens next, right? So for me, never take a penny wise, pound foolish. Never make costly saving, right? You might want to write this down. Never make a costly saving when you terminate an employee. Never take a penny wise, pound foolish. You want to save a few cents here, but you got to pay many more dollars later. Penny wise, pound foolish, right? Now, the medical assessment form, I've shared, we have a sample in the forum. It is a very comprehensive form. If you have not seen it, please go to the forum. Please type in medical assessment form, or sorry, medical surveillance form, right? It's a 4-page form. It's guided, right? And you every quarter, you tell the doctor, please fill up this form. Our format, you fill it out. We want to know what is it. So after 4 assessment, you can look at the form and then make a decision whether you're going to keep the employee for further, further observing, or I think this is it. We need to make the next step. We need to take the next step. So this rough funnel. Let me run through a few cases, right? Now, in the case of MHS Aviation versus 𝙎𝙊𝘾𝙄𝘼𝙇𝙎, this was a case in 2001. So what happened in this case? The employee, he was diagnosed with acute inferior and posterior myocardial infarction, right? The court said that the termination was unfair. Why? Because the company had not made any inquiries on this illness. So that means the company issued a termination notice merely based on assumption, right? Remember, no assumption. You got to find out. How do you find out? You cannot say, hey, employee, what's wrong with you? Why were you absent? Right? Show me your report. Now, to me, that is incomplete. Firstly, we are not a medical practitioner to understand. We can't interpret doctor's report. So that is why it is always advisable to have your panel doctor, preferably a specialist, so that he is able to study the case, evaluate based on his expertise as a medical doctor, and advise you whether he or she is fit for employment, fit to work, right? So that's one. The second case of Gopalakrishnan versus Goodyear. Now this guy, he suffered from a recurring knee injury. He was terminated on medical grounds despite working for the company for 11 years. Now, the judge in this case says what? When you bought out an employee, when you remove an employee, terminate an employee because of medical issues, you are expected to act reasonably. You must be reasonable in accordance with your obligation of social consciousness. You see, as an employer, we have this obligation, and this obligation not written, right? It is not an express, it is an implied. Bukan tersurat tapi tersirat, right? It is an implied obligation of social consciousness. And what it says here, we should attempt to offer an alternative employment to the employee, although it may be a lower paying job. So there's a question asked, I saw a question being posted, can we offer him a lower job? Yes, because in order to keep him in continued employment, at least with some, salary they can survive, you should make an offer, attempt. Again, not a must. Must you? Not a must, but you should attempt. Attempt meaning you must try to make, make an attempt, or you try for it, right? Try it out. Try, find it if there is. You should attempt to offer an alternative employment to the employee, although it may be a lower paying job, right? So now, if let's say I have a technician and his salary is 4,500 ringgit, and his job is quite a physically strenuous job. That means his job requires him to, let's say, climb up the machine, carry heavy load, and be in the environment where it's noisy. He's got to stand for long hours, etc. Now, because of his condition, he cannot do this job anymore. His salary 4,500. But I've got a job in the store. Let's say in the case of a manufacturing or warehouse, I've got a job in a store where his job is to record all the inventory in, inventory out, and no need to carry barang-barang. No need to stand for long hours, because this job, you're given a laptop or a computer, you sit, you record in, out, documentation. But this job only pays the maximum salary for this job, 2,800. So what you do, you make an offer to him. If he refuses to offer, document it, and then you tell him, then you don't have any other choice but to terminate you on medical grounds. Right? So that's what it says. And frustration of contract. So this is another terminology. For some of you all, you may be hearing it for the very first time. What exactly is meant by frustration of contract? Short form, we say FOC. You will not find this terminology, right, in Employment Act, because this comes from the Malaysian Contracts Act 1950. So this is the act of all contracts. Under section 57.2, it says this. Now, I mean, I will not read it because it's a little bit legalistic. So I'm just going to read it to you I'm just going to explain a very layman term. So in a contract, two parties form a contract. Employee, employer. A buyer, a seller, right? There's always two parties to a contract. Now, in the event, if either party, whether A or B, whether it's employee or employer, right? It doesn't matter. If either party, right? Once the contract, we have signed the contract, and after that, if either party, because of some event, because of some issue, if either party can no longer fulfill the contract, that means either, let's say, for example, employee, he met an accident, he cannot work anymore. Is it his fault? Not his fault, right? So the contract becomes what we call as frustrated. So if the contract is frustrated, frustrated contract, because the contract can no longer be carried out, can no longer be fulfilled. That is called frustration of contract. So now, and this we saw in the case of MHS Aviation versus 𝙎𝙊𝘾𝙄𝘼𝙇𝙎, where the court says this. So you can read it. It's a bit legalistic to read it. So when does frustration apply? Frustration will only apply where there's an event or circumstances which we cannot foresee, right? And where it occurred. So, and it occurred through no fault of either party. It is not the fault of employee. It is not the fault of employer. For example, if an employee becomes sick or he dies, he cannot perform his job anymore because of his medical condition. It is not his fault. Nobody prays to God, please make me sick. No. They become sick, they become incapacitated. So not their fault. Or let's say a company, the warehouse burned down, cannot continue work anymore. Now the warehouse, did it burn down because the company put it on fire, or there's some act beyond the company's doing, right? So this is what we call as, through the no fault of either party. So if this happened, then you frustrate the contract. But if an employee committed a misconduct, that is not frustration of contract. Because why? You did it. Or if the employee cannot perform, that is a doing of the employee. So that is not frustration. You terminate them on disciplinary issue or performance issues. But if an employee dies, they become ill, they cannot carry on their work anymore, they become incapacitated. Now, this is what we call as frustration. Another form of frustration is when the employee is under police detention for an infinite period of time. That means for a period that you cannot foresee. Now, can an employee, let's say you frustrated a contract or you terminated them because of medical issues, can they file a case for unfair dismissal? Answer is yes, they can, right? So in the case of 𝙎𝙊𝘾𝙄𝘼𝙇𝙎 versus Nolan, this is I think UK case, it says this, an employer cannot be expected to go unreasonable length. How long can I wait? How long should I wait? How long should I accommodate someone who's not able to carry out the job he or she was hired for, right? You cannot be expected to wait forever. Now, so I've done that on frustration, and let me just cover a few more cases, and then we can talk about, questions that you have for me today. Malingering, right? Malingering means what? Malingering means the employee is not sick, but pretend to be sick. So I repeat again, malingering means the employee is not sick, but he managed to get MC from the doctor, but he's not sick, right? That means, in other words, he feigned or he faked his sickness. Not sick, but he got an MC. I know sometimes you will blame the doctor. How come the doctor gave MC, etc.? Now, what happens and I'm just giving you a worst case scenario, a very weird or very funny example. An employee woke up 10 o'clock. Alamak, 10 o'clock already, late to work. If I go to work today, surely my boss will, he will scold me. Deduct pay, no, what do you call that? Show cause letter, warning letter, and so on. So what this employee do? He woke up at 10 o'clock. He don't have a shower. Just wear some terrible looking shirt, never comb the hair, take minyak cat kapak, rub all over his eyes fair, maybe bathe minyak cat kapak, smell, right? He go and see the doctor. He goes to the doctor and say, "Doctor, malam tadi saya 𝙎𝙊𝘾𝙄𝘼𝙇𝙎, doktor. Tak boleh tahan, doktor. Saya malam tadi 10 kali pergi tandas." Right? Now the doctor is going to look at his condition and say, "You look bad, right? You look very bad. I don't think you can work today. So I give you 1 day NC." Actually, he's not sick. He faked it. Now the doctor is not going to say, right? "Oh, yalah, your condition very bad. Really, you went to the toilet 10 times. Okay, tak apa. You duduk sini dekat klinik. Saya nak tengok berapa kali you pergi tandas." Doctor will not do that. Some illnesses, right? The doctor will look at your declaration. So when the employee claims that he's sick, basically he's making a false declaration, right? To avoid work, he falsified his medical condition. So he's not sick, but he pretended to be sick. He appeared to be sick, but he's not sick. Now that is a misconduct. Now remember this, if the person claimed to have diarrhea, what do you call this? Migraine, back pain. How do you prove this? Fever can be tested. Flu, you can look at it. Urine infection, you can do a test. But how do you test migraine? How do you test back pain? How do you test 𝙎𝙊𝘾𝙄𝘼𝙇𝙎? You can't. So doctors sometimes will decide to give MC to the employee based on employee's declaration. So in this case, the employee made a false declaration. So that is called malingering. So malingering is a misconduct. So let's look at it this way. And so let's say two scenarios, right? Scenario A, employee was not sick, but pretended to be sick and got an MC. That is a misconduct. Scenario B, the employee was genuinely sick. Doctor gave him MC, he's resting. So here, the one that is not sick but pretend to be sick and got an MC is a misconduct. That's called malingering. An employee who's sick, genuinely sick and got an MC, that is not a misconduct. That is a genuine sick leave. So you got to be able to differentiate these two. Right. In the case of Regent Kuala Lumpur versus Gerard Anthony, the industrial court said this: the employee was guilty of malingering. He was not sick but pretended to be sick, got an MC. But on the same day, he attended a family day function at the hotel. Right? So that is malingering. What about excessive medical leave? Some of the cases that you may have today, employees take excessive. Excessive means, of course, when you ask me what is the definition of excessive, is it 2, 3, 5, 8, 10? That you have to decide. Excessive means, if you ask me in a layman term, more than usual. If other employees, in a year takes about 5, 6 days, why is this guy taking 14 days or 18 days? Now that could be deemed as excessive, but there's no fixed formula or definition. Excessive means more than 5. So excessive medical leave and abuse of MC. So now what the court said is, when an employee takes an excessive MC, this is an unknown, right? It's an unknown misconduct. So what happened? Now this case went to the industrial court, then went to the high court. The high court said this: taking excessive MC, that means taking too many MCs in order to avoid work, in order not to come to work, in order, and he was not willing to perform his job. So he take MC, excessive MC to avoid work. That must be a misconduct. But if an employee genuinely falls sick, I don't know whether you agree with me, I have seen employees every 2-3 weeks fall sick. Those people with sinus, asthmatic, every now and then there's asthma attack, MC, asthma attack, MC, sinus, MC, right? Now, these people, they are genuinely, maybe they are, antibody is weak, they're easy to fall sick. Now, that cases are not misconduct. because they are genuinely ill. But people who frequently are sick leave just to avoid work and they're not sick, that's a misconduct. What happens if an employee, you know, if you look at this case in 1979, 49 days, 1980, 23 days, and also the same year, another 7 days. Now, what happened in this case was the company sent this employee for the physical assessment, to be assessed. So the doctor certified him physically and mentally fit. And because there's no evidence from the employee to prove otherwise, right, that he's unwell, to prove that his health has deteriorated from the period of August, September, the court agreed with the company that this employee has no serious or long-standing illnesses to account for his excessive medical leave. So how I normally manage these cases, the burden is not on me to prove why you are on sick leave. Why are you taking so many leave? The burden is not on me. The burden is on you to explain why you're taking too many sick leave. So as HR practitioner, as HR department, don't put everything on your head. Don't burden yourself to go and find evidence to prove. Turn the table around. Tell the employee, now look here, right? Let's say Chong. Look here, Chong, you have been on sick leave for too many days and we are concerned. Can you tell us why? So please go and see Dr. Jason. He's going to assess you. Please bring all your documentation, evidences. Let Dr. Jason assess you, right? If Dr. Jason assesses you fit to work, that means you are not able to account for your illnesses. We may take further action on you. Turn the table around. Don't put everything on your head. Now, in this case, right, this was taken from Mr. Ganapati Ramaswamy's book, Discipline at Work. So in this case, if you look at the chronology here, 1994, 35 days. The following year, 47 days. 96 or 48 days. And in 1997, 51 days of sick leave, right? So what happened? This employee, he was subjected to a counseling session for his medical history because he claimed, right, he says that he had gastric and operation to his stomach, which caused a medical problem. So he underwent a compulsory medical test. And the doctor certified him fit for normal duties. So he was given final warning. So you see here, the doctor certified him fit for normal duties. He underwent a medical compulsory test, and the doctor then certified him fit. He was given a final warning and reminded to change his attitude and behavior towards work. And because there was no improvement, he was suspended and subsequently he was dismissed on disciplinary grounds. Because why? He was given, and this is more of a disciplinary issue if you ask me. So what the industrial court says this, any worker, and I mean, even whether industrial court said it or not, but it's common sense, right? Anybody can fall sick, right? So what the industrial court said in this case, any worker is liable to fall sick. If you're not well, you're going to fall sick, you fall sick. You know, because you're absent, you're fall sick. That's fine. So any worker is liable to fall sick to justify their absence. However, malingering, that means they faked their sickness. They are not sick, but pretended to be sick. So malingering is an abuse which amounts to falsity underlying the abuse. That means they falsified it. So that's a misconduct. So what he also says this, employers, you must be sympathetic. You must be empathetic. If your employee is not feeling well, you must provide support to them, care for them, right? For those people who are genuinely ill. But you must also keep a watch out, keep a lookout for those employees who abuse the medical privileges and ensure they follow your company rules and regulations, right? So this is some cases that I would like to bring up to your attention. Now, question to you, how do you spot an employee abusing their medical leave? How do you spot it? Anyone? I just need one listener here today. Share with me. How do you spot an employee abusing medical leave? Anyone? Okay. So anyone, you can share with me, how do you spot? Right? Agreed? Clinic hopping. There's a pattern of MCs. Right? MC every Monday. Thanks a lot. Right? Good. And then MC every Monday, MC every Friday, MC before public holiday, after payday, and not just one time. One time is not a trend. When this employee does this very frequently, then it's a trend, right? Every year, always finish off their leave. If you look at the last 3 years, always 14, 14, or if it's 18, 18, or whatever the number of entitlement they have, always exhaust their sick leave. That's a pattern. So when you see a pattern, right? When you see a pattern, that's when you start monitoring. Now, my advice to you is don't jump on every cases. If you're very free, you've got nothing to do, or maybe your job is only this, then fine. But look at those, cases that is too routine, right? The moment they exhaust their sick leave, hospitalization leave, that's when I would react. So not every case, right? Okay, so thanks a lot for answering the question. And yeah, so thanks a lot for answering the question. Yeah. So thanks a lot for answering the question. And yes, any other, yep. So please share your questions. So I'm going to answer your questions in a very short while, right? So let me now just quickly run through a little bit of things that we do before I go to Q&A. Now, we do have the employee handbook, right? And in the employee handbook, we do cover PIL. So for those of you all, if you want the employee handbook, editable version, if you don't have one, if you're going to sit down and crack your head for next 3 weeks, 1 month, 2 months to do a handbook, well, there's an easier way. We have an editable template. We're not giving out for free because, we also need to make some money out of it to run all these things that we do. So for those of you all, if you want the employee handbook, we've got a foreign workers handbook and also local workers handbook. If you want, you can purchase via the link that I'll share with you later. And also for those who are listening in today, we would like to also share with you that we do have a comprehensive IR and EA advisory package. Now, this package is where, right? Oh, sorry. Yeah. So, yeah, IR and EA advisory package, which allows you to call us when you have an issue. You call us, our advisors here will advise you what to do, how to do, right? That's the only first part. It can be on EA topics, IR topics, social compliance, collective agreement, and we can also help you a little bit of basic documentation review, but this doesn't include handbooks and SOPs. But what is more interesting is this is not just an advisory where we become like your helpline. Whenever the issues we call, we answer. That is, yes, it's given, we do that. But we also want to build your capacity. My question to you all is, how long you're going to call for help every time you have an issue? 1 year, 2 years, 5 years, 10 years? How long? So what we are more interested is to build your capacity. Yes, you have an issue, you call us, we tell you what to do. But we also want to build your capacity. So part of this capacity building is, if you are signing up for this, and if you are the person in charge, you will also go through 12 modules for 1 year. And you'll be going through modules such as Employment Act, IR Act, Domestic Inquiry, Managing Employees with Medical Conditions, like what we've gone through today, but a more comprehensive one. How do you prepare for industrial court hearing? How do you prepare for IR conciliation cases? How do you terminate employees with medical issues, disciplinary issues, PIP, probation management, or there are also optional topics on trade union, social compliance. How do you draft legal letters? How do you manage foreign workers? Case investigation, sexual harassment. So we train you as well. Now, some of you may already be subscribing to another advisory service. Now, if you're happy with it, please continue, right? And so on. But if you don't have one, or if you want to change the way you do things, you don't just want to always rely on people answering your question. People, every time the issue, you call us, we tell you what to do. You also want to start learning up. This would be an ideal package for you. The total cost 15,000. Of course, the moment you say, wow, 15,000, so much. Well, it is 1,250 ringgit a month. After 1 year, let's say you take up this package. After 1 year, you said, Arul, I think I'm quite well versed now. Can I stop this? Please stop. We are not expecting you to continue forever. After a year, maybe 2 years, you feel now you're competent, you stop. Now, no point of you paying 5,000, 7,000 every year. You pay every year. So if you look at the total cost, it could be 40, 50, 60, 70,000. When are you going to start surviving on your own, right? We cannot always expect somebody will help us to feed us when we're hungry. I want to Yes, we'll feed you when you're hungry, but we also want to teach you how to catch the fish yourself one fine day so that you can survive on your own, right? So that is that's a little bit of our advisory package. And of course, if you sign up for this package, whenever we issue our employee handbook and any other guidebook, right, you get it for free. I'm sure you have seen all our templates in the forum, but when you become an advisory package subscriber, you will get all the documentations. There are many documentations we don't share in the forum because that we reserve for paid clients. You'll get the soft editable copy, conference passes whenever we have one, free passes for you, and any of our public programs. If you sign up as as a member advisory, you get 15% discount. There are also a lot of complimentary trainings that we give out for free, and also complimentary use of training rooms. There are also private webinars. Today's webinars open to the public. There are also private webinars we do for our paying clients, which is very much more focused. It can be longer than 2 hours. It can be a face-to-face workshop. So, but what is more interesting is not, Talian Hayat for you, advisory line. Hey, Arul, I need help. We answer you. But what is more critical is for you to develop your capability, right? Instead of asking, hey, can you help me to proofread my letter? What if we proofread today, but at the same time, we also teach you how to write letters, how to write policies, how to prepare your handbook, so that after 1 year, you become competent, right? Okay, so let me, and of course, for those of you all interested in the masterclass, so this is a program that we do for all IR practitioners. Now, this is a 2-day program. You learn on the fundamentals of EAIR, you learn about strategy, you learn about PIP, and whatever topic we discussed today in more detail, amendment to the law. You'll get policy templates, handbook, how to reduce your workload. For example, now, I just want to ask this again, my favorite question again. Unfortunately, it's not this advisory package, it is not HRD COP claimable, right? You got to pay from your pocket. This masterclass, it is HRD COP claimable. Now, let me ask you this again. How many of y'all, how long do you take if an employee did not come to work, tardiness, or some negligence? How long do you take to issue a show cause letter until you complete a warning letter? How long does it take? Let's say the employee did not come to work yesterday. How long do you take to issue a show cause letter until you complete the process with a warning letter? How long? Anyone? 1 day, 1 week, 2 weeks? Anyone? I just need one answer. How long do you take to issue, from the time you call the employee to HR until you issue the warning letter? 1 week, right? Okay, so what if I tell you, right, 1 week? Now, what if I tell you I do it in 20 minutes? You work hard, I work smart. And I still follow the law. I still don't break the law, right? So how do I do it in 20 minutes, but you take 1 hour? Or sorry, you take 1 week. Some of you will take 2 weeks, right? So to know more, please join our masterclass, right? Or become our advisory client. We'll give you all these tips. You can simplify your work by almost 20% after attending the masterclass. So what is it? We give you shortcuts, legal and valid shortcuts, removing some of the processes that is totally not required at all, right? So we'll cover this during the masterclass. So let me just answer your questions, right? We have got 1 hour, so stay tuned so that I can answer as much as I can. Yep. Okay, so let me just run through some of these questions. Now, Carol says this: the employee did not inform on MC until we called them. How do you do it differently? I do not know whether you want to believe me or not. There are effective ways to manage every issue you highlighted, but because you're not aware. Like me, I know what to do, how to do, what to do, and so on. So you've got to be aware on how to manage these cases. Firstly, I will write a company policy or a memo. I will tell employees, if you are not coming to work for the day, it doesn't matter what, you must, of course, if you're annual leave, different story, because annual leave, the employee applies ahead of time, right? either 1 week, 5 days, 3 days, they apply ahead. I know when you're on annual leave. But if you're applying for other than annual leave, emergency leave, I will not apply because emergency, right? Today is emergency. Anyone not able to come to work must inform the superior before commencement of work. That means before 9 o'clock, they must inform you. If your work starts at 8 o'clock, they must inform you before 8 o'clock. Make sure your number, your phone number, every employee has it. So if I have an employee who failed to who failed to call me up, that's a misconduct. He may say, boss, I got MC. But company policy says what? You are supposed to inform us before if you're not coming to work. Now he may say, hey, Employment Act says this, within 48 hours, you must either inform or attempt to inform. I will put that aside. Company policy says you must inform. Right? And you may tell me, or should I not follow the Employment Act? Now, Employment Act was drafted many years ago when we don't have any WhatsApp phone. Today with WhatsApp, I know where you are, what you do. I mean, you can always tell us where you are, what you do. A simple message is enough, right? Now, the problem is in our company or in your company, you have never set the right culture, right? I'm not sure, for those of y'all, if you go and visit a Japanese employer, a Japanese company, the company usually is very orderly. You cannot walk here, you must walk here. There's a bell at 12 o'clock, all go for lunch, 1 o'clock, all come back, and so on. Similarly, for those of y'all, if you have driven into Singapore, in Malaysia, wow, we are king. We can drive at 150, 160, and so on. But the moment we enter Singapore, we don't need the Singapore police to tell us. Automatically, kita dalam keadaan berjaga-jaga. Because why? We know in Singapore it's strict. Now, if your company culture is strong, the culture of discipline, employee will automatically comply with you. But if your company is operated in a cowboy fashion, kelam kabut, lintang kukang, people will, it's okay lah, never mind lah, no worries. So the failure of employer is to create the culture of discipline. If you have a culture of discipline, almost every employee of yours will comply. So that's a challenge for you. So if you now tell me, I need to call, and people don't tell us, I need to call, that means your company culture is weak. Which culture? Culture of discipline is weak. So now there's this person, or this employee, met an accident. His palm broken, right? He broke his palm and he got an MC. Recently, he went for another appointment to see whether his bone is fused or not. The doctor gave him another 3 weeks. Then his employee called him almost every day, asking him when is he going to start work. If he don't resume work, the employee will find another person. Now, question is, couldn't the employer offer a lighter job, right? Now, firstly, I would say, this is my view, employees are not obliged to offer a lighter job. What if there's no lighter job, right? What if there's no lighter job? If there's a lighter job, maybe I can offer to you, but I don't have a lighter job. All our jobs are heavy, right? So that could be one scenario. But my advice to employees is also this. If you can temporarily create a light duty or a modified duty for a short period of time, so that when the employee is recovering, at least he can do some job. Now, even if the job pays him a little bit, offer to him saying that, okay, dear Jason, now your condition do not allow you to resume your normal work. However, we do have a storekeeper position vacant for time being. We are okay if you take up this job for temporary need during your recovery. Once you're fully recovered, you can go back to your original job. You can also do that. And I would say that that's a good practice, right? So if you can create one or allow him for a temporary period to do either a modified duty or light duty, I would encourage that highly. But if you don't have one, you can't create one for temporary needs, then there's nothing much you can do. So regarding the MC duration, what is the maximum duration if the medical condition related to bone injury? Now, unfortunately, I'm not God. and I'm also not a doctor, so I wouldn't be able to advise you how long, right? It is only the doctor who can advise you. Sometimes, right, even the doctor, they also will look at reports, employee's condition, employee's declaration, and the doctor may have to look at the scenario from time to time. Now, you can always have this scenario as well. The employee, broke his hand, but when the doctor takes an x-ray, it all looks perfect, right? X-ray looks perfect. However, the employee says that, doctor, walaupun nampak macam tu, bila I tutup tangan tak boleh, doktor, banyak sakit. Actually, he can close, right? Actually, he can close, he can do all. But when he see the doctor, he said, doctor, so doctor said, okay, let me try. Doctor sakit. Now, he may be freaking it out. What can we do? Right? So, I mean, sometimes some irresponsible employees can be creative. So, I will not blame it on the doctor. Doctor is also not God. They can tell you yes or no with a very definite answer. Okay, recovery is 3 weeks, guaranteed. Only God will guarantee. Doctor cannot, right? Doctor will have to assess them based on their medical expertise, based on employee's condition, based on the reports, based on the employee's, input and declaration. The doctor can give a much more better advice. But I can tell you, there's no way anyone in the world can give with high certainty how long this recovery will take. So Amanda, could you please share the medical surveillance form? Well, when you get these slides, we'll share the link, but it is also available in the HR Forum. Just when you go to HR Forum, in the search button, you type medical surveillance form, you'll get a copy of the form. So there's a question from Carr. Can we also include company policy that employee must apply medical or emergency leave on leave system, right? On leave system, hang on a second, on leave system before commencement working time. If they fail to apply before the working time, it can also be misconduct. Now, this, I'm a little bit jittery, right? I'm a little bit, concerned on this. Medical leave, they can't apply beforehand. Because why? I can't apply leave yesterday. How do I know? Maybe night, suddenly, I develop high fever. I'm not in the condition, I'm really sick, right? I can't open up my laptop and apply. So what do? Now, some employees don't even have access to leave system. Some companies, they are using manual system. Some companies, they got to apply using a paper. Now, if I'm at home, how do I apply using paper? Or maybe I don't have a laptop. Or maybe I don't have a login to the system, right? Or maybe I lost the password. So there are many, reasons why an employee cannot apply. So to me, I will not, do this. But if the employee, if I find that they are, this thing is becoming very frequent, very routine, send them for assessment, limit their clinic, counsel them whenever needed, right? Rather than doing this. Same goes emergency leave. If the employee has access to leave system and your company is all fully automated, then it's okay, right? But to me, the minimum they can do and the minimum they should do is inform the superior, right? WhatsApp the superior, boss, today I'm not feeling well, I can't come to work. That's it. At least as a superior, I know he's not coming, so I can quickly arrange my work. But if the employee only tells me after 12 hours, after 24 hours, or within 24 hours or 40 hours, I can't arrange my work, right? I cannot be waiting at the doorstep. When is this guy coming to work, right? That is why the culture of discipline is important. So I would urge employers, number one, firm up your policy. Educate your employees. Communicate to them. Always remind them. Take action. So there's a question from 𝙎𝙊𝘾𝙄𝘼𝙇𝙎, right? EL, emergency leave. There's no provision for emergency leave, right? Road accident need to define kan. To me, an accident is an accident, right? Emergency leave, if it's because of, it's a bit weird lah. A person apply emergency leave because they're sick. If they're sick, normally people apply sick leave, right? Emergency leave for other reasons. Maybe anak sakit, need to go to the bank, or maybe there's some emergency. Going to the bank is not emergency, yeah. So even emergency, in my view, you can also define what is emergency, what is not. Emergency typically is something that happens, requires your attendance there, which you couldn't foresee yesterday. Maybe the kid falls sick, parents fall sick, right? Or maybe your car, you met an accident or tire punctured and you cannot do anything because there's no workshop nearby. So those are emergency. But if the person falls sick, it's sick leave, right? Jali asked this question. If an employee already sick, sorry, already recovered and went for follow-up consultation with the doctor and given an MC slip, can the company reject and ask the employee to apply his annual leave? Well, as long as the doctor gives the employee MC and the employee has still unutilized MC, that means he's out of the 14 days. Let's say the employee less than 2 years, 14 days, right? So the employee has only utilized 7 days. He's got another 7 days. And the doctor gives him an MC. It is MC, it is sick leave. You cannot force him to apply annual leave, right? Unless if you find that something is wrong, then you send the guy for assessment. You know, I've seen cases where employee yesterday, today all feeling well, looks okay, perfectly fine. Tomorrow MC. Then the next day come back, perfectly fine again. This is very common, right, in the old place. Monday feeling well, can go makan, chit-chat, borak. Tuesday sick. Wednesday come back, can continue borak. What kind of illness in one day they become sick? You know, they become so sick they cannot come to work, but the next day they are perfectly okay. I can tell you, these are also cases of employees. Chances are they could be malingering, right? It's very strange. Today perfectly well, can play badminton, suddenly tomorrow ill. Then the following day, come back to work. What I will do, if I see this first time, okay, never mind. I give benefit of the doubt. Second time, never mind. Third time, assessment. So you can send employee for assessment. And another tip that I want to share with you is in your misconduct policy, right? Please add a line in your policy. It doesn't matter whether misconduct or the medical policy, doesn't matter. Employee must attend, you know, any medical examination or assessment when instructed by the company. So that means if you tell the employee, you please go and see Dr. Jason for assessment, he must go. Failure to go is a misconduct. Remember this. This is part of insubordination. Insubordination means what? Refusal or disobey any company instruction that is lawful and reasonable. That is insubordination. So if you want to ask employees to go for medical assessment, please make sure it's covered in your policy as well. So there's a question by 𝙎𝙊𝘾𝙄𝘼𝙇𝙎. If the staff has fully utilized MC and hospitalization leave due to undergo surgery and still not recovered, so employee underwent surgery, hospitalized surgery, and not fully recovered yet, doctor still give MC, yeah, that'll be it. So if doctor still give MC, that'll be sick leave. Now, if the person is hospitalized, it is hospitalization leave. Now, this employee, let's say after surgery, was in the hospital for 1 week, that is hospitalization leave. The doctor may discharge them and for them to rest at home. But the doctor says we can still consider them being hospitalized. So you use hospitalization leave, not sick leave, right? And this provision is provided for in Employment Act. So I would urge you, right, to go and download a copy or get a copy of the Employment Act, the most recent act. Mr. Toh Siew Phat has shared the latest copy of the amended act, dated this year. It is shared in the forum. Please search Employment Act 1955 amended version. Download, read the sick leave clause in detail. One of the items mentioned, if a doctor deemed that this person is hospitalized, then they're deemed to be hospitalized, even though they're home, that is hospitalization leave. Okay, Tila Krishnan asked this, sir. We provide attendance allowance to workers, but if workers takes MC, the allowance considered burn. Now, in this case, if the worker has an MC, he or she converts to annual leave. Is that okay? Well, I think attendance allowance, the condition of attendance allowance, you got to attend work. So if you don't attend work, that allowance will not happen. So that is why it is important to specify in your attendance allowance policy, or if you don't have a policy, in your terms and conditions for attendance allowance is only given when you attend work. Same goes to transport allowance. If you're giving employees transport allowance of, let's say, 5 ringgit per day, the transport allowance given if you're at work, if you're resting at home, you did not perform the journey, why should I give you transport allowance? If you did not come to work, right? I'm paying for your sick leave. But why should I pay your attendance allowance? Because you're not attending work, right? So attendance allowance and transport allowance is only when they come to work. So spell this out in your policy. Now, if you don't, if we take things chincai here and there, and we don't spell out a policy, now chances are you'll be in haywire mode, right? So one of the things that we do in our advisory package, right, is, we don't just wait for you to call us. You may not call us, no issue, you may not call us. We will call you, okay, all members who are paying, please come to our academy, which we're going to set up very soon. Please come. Today, we're going to review our medical policy. Let's do it as a group. Let's do it together, moderated by the advisor. So these are things that we're going to do. So you need to now take a different step. Don't follow the old-fashioned method. I only react when issues happen. Please take the preventive approach. Before it happens, you take the action, right? The slides will be shared in the Facebook, right? Once our session is done, we'll share these slides in Facebook. You can download the slides. Certain links like the PIL and all that, we'll share it. So download it, make the best use of it. Okay, so any other inputs? Not able to see all inputs, but is there any others? So any other inputs? Any questions? You can also ask me now. Okay, thanks for asking, Pika Bella. If the staff had fully utilized the MC, can we deduct salary based on MC record? See, now, do we need to have staff consent for salary deduction? Firstly, I hope I got you correct. Now, when the employee is given 14 days, is given by law. 14, 18, 22 is given by law. So if they're sick, and let's say you have an employee who has worked for you for more than 5 years. Entitlement for employees more than 5 years is 22 days. Am I right? So if an employee is sick and he can use his MC, you cannot deduct salary because he's still entitled to utilize the sick leave of 22 days that is given to him by law. Now, let's say the employee continues to be on sick leave and he is exhausted. Sudah guna pakai cuti sakit, tapi masih sakit lagi. So what do? He will then go on unpaid leave. He will go on unpaid leave because unpaid leave, why? He got no more MC, so he takes unpaid leave. Now, if the employee has annual leave, he says that I need the money, can I apply annual leave? I would allow him, right? But I would say, spell out in your policy, if unpaid leave finish, I would strongly advise, if MC finish, I would strongly advise unpaid leave, just to make this thing clear. Because later part, if the employee wants annual leave, for other reasons, he can apply. Remember this, unpaid leave, company can reject. So if you allow employees to use annual leave to offset his medical leave because no more MC, tomorrow, let's say he wants to apply for Deepavali or maybe Christmas or Raya. If he's going to apply unpaid leave, you have the choice to reject. But annual leave is a different story. So that is why I believe in keeping things clean cut, clear, so that no, mix up here and there. Okay, there's a question by Hidayah. It's a very interesting question. If the employee refuses to resign, even if his MC and hospitalization is fully utilized, what can employees do? Now, there's no such thing out there that we can terminate employee if they exhaust their sick leave, hospitalization leave. No such thing, right? Remember the funnel? Just because they utilize it doesn't mean you can terminate. Now, if you're going to terminate because of their medical condition, there are few prerequisites, right? So Hidayah, you may want to, if you have not captured what I try to say, please repeat this webinar. So this webinar, by the way, it is recorded. It is going to be saved in Facebook, Malaysia HR Forum Facebook. When you're free, perhaps watch it again. Listen closely to what I've said. You cannot terminate an employee just because they've exhausted their hospitalization and sick leave. So what employer got to do? Put them into medical process management, run through the funnel, and then decide end of the day. Again, some of the questions that you're not asking, but I would like to share this with you. MC, can I not give MC to an employee during probation? Like some companies, you don't give annually during probation. Unfortunately, MC and hospitalization leave must be given from the first day of their employment. You cannot wait until they complete probation. Only annual leave. You can wait until probation, or you can give after finishing 12 months, after completing 12 months. But for MC and hospitalization leave, they qualify from the first day, even though they are on probation. If the staff went to clinic to get an MC, doctor refused to give an MC, they start making a ruckus. That means they start making noise lah, haywalk, demanding for MC. Before they can leave, can the doctor call the company to complain? What action can we take? Now, I don't think you can take any action, because why? That scenario, that incident is happening outside your premises. But what the doctor could do is to make a police report. Because, you know, under our criminal procedure code, right, it says this, public nuisance, I can't recall the exact terminology, but public nuisance, mengganggu ketenteraman awam, and all those things is a offense. So the doctor can make a police report. Tell the doctor, please make a police report that he's creating ruckus at their place. But you as an employer, I don't think it's easy to take an action on him, right? The closest action you can take, in my view, is to issue a show cause letter to him for damaging company's reputation at an external premise, right? So again, I would urge you one more time, download the disciplinary policy that we have in the forum. It is a very comprehensive policy. Sample is in the forum. Download the policy. See the items that we covered. What I've just mentioned, you know, creating, you know, damaging company's image outside can be a misconduct, right? Check out the policy, capture this, but then again, what action can you take? That we need to look into the circumstances of the case. You cannot just say, just because he created ruckus, I give him a final warning letter. No, you give him a chance to explain, see what is the issue all about, perhaps a first warning for the very first time. If the employee have prolonged or prologue pregnancy issue and not working for 4 to 5 months with no medical cert or hospitalization cert, how do we handle this issue? Employer cannot terminate the pregnant staff. Now, there's two ways to look at it, in my view. There's two ways to look at it. Number one, if the employee has been on prolonged sick leave or hospitalization leave, right? Firstly, they are not coming to work. No sick leave, no hospitalization leave. What do we do? Well, I would say the employee is going to be unpaid leave, because annual leave only 14 days or maybe 8 days, depending on what your company provides. Could be 8 days or 12 or 14 or 16 or maybe more. Once they've exhausted their annual leave, they will be on unpaid leave, right? Now, unpaid leave, you have a choice to reject. If the employee is unwell, maybe the first time, second time, I said, hey, why are you not coming to work? Or because I'm not feeling well because of pregnancy. Okay, but do you have an MC from a doctor or, you know, from a doctor or a hospital? I don't have. I tell you what, company policy says what? Now go back to your company policy. What does the company policy says? So I believe when you ask me this question, that means the company policy is all plum cupboard lah, right? If you must address your company policy well, saying that failure to attend work is a misconduct, unless the employee is on leave, annual leave or sick leave. If you're on sick leave or hospitalization leave, you must be able to back up with a MC or a hospitalization leave certificate. Otherwise, it's absenteeism. Absenteeism, issue show cause letter. Now, Employment Act says this, if an employee develop an illness arising out of their pregnancy, you shouldn't terminate them for that. But in this case, you don't know what is happening to the employee, no report from the doctor, no medical, nothing, zero. So in this case, what I would do if I were you, send the employee for medical assessment, go back to the funnel. You see, this question is answered in the funnel. Go back to the funnel. They're not coming to work, send them for assessment. If they refuse to go, it's misconduct. If the doctor says employee is perfectly fit, start issuing show cause letter, even though they are pregnant. So what, see, you may think that I sound very inhumane. Now, we are not inhumane. We can always tell the employee, look here, if you're not feeling well, we understand. Maybe it's your first child, right? First child, normally it's a little bit challenging. We understand. See the doctor. If the doctor gives you MC, we understand. Or the doctor says, you got to rest at home, we understand. But maximum annual leave, maximum hospitalization leave for below 2 years of service is only 14 days. 14 days MC, otherwise unpaid leave, right? I know of companies who actually allows employees to go on unpaid leave when the doctor says, yeah, first pregnancy, morning illness, maybe a complicated, right? You might want to ask, if you have a medical practitioner, an employee who's pregnant, and if she has got this, I don't know whether I got it correctly, but fibrosis or fibroid, normally they go through a very difficult pregnancy. Now, they may be having issues. We do not know. That is why always send her for assessment before we jump the gun, right? I will not want to jump the gun saying that, oh, this person is terrible, not coming to work, etc. It's okay. I can understand. Please see Dr. Jason. Bring all your medical reports to him, etc. Let him assess your condition. Let him tell us what's the issue. If Dr. Jason says that, okay, so-and-so is not, is going through a difficult pregnancy, I advise her to be given rest. I will understand, right? That is why use the doctor's assessment as a way to manage this employee. Okay, so this is another interesting question on PIL. Aziz asked this. PIL, you usually encounter PIL 6 months full pay, 6 months half pay, and 6 months no pay. Now, 666 is 18 months. It's a very long period. My question, Aziz, do you need it that long? Right? 18 months. Okay, but if your company is okay with it, fine. Right? If you're okay with it, fine. But I personally feel 660 is too long. But if you're okay, then I'm okay. Right? At the end of 6 months, is it possible to make the policy shorter? But how do you make it shorter? If you have guaranteed 666, how do you make it shorter? What you may want to do is bring this up to your management, evaluate your current need, and see whether 666 is feasible or should you shorten to maybe 333, right? Now, if you ask me my personal view, right? My personal view, I would say 333 is a good period, or 633 is a good period. 1 year is just nice. Less than 1 year, I feel is a little bit too short. More than 1 year, I feel it's a little too generous, but there's no right or wrong here. You decide what is okay for you. But you cannot suddenly cut it short. That is why I would urge you revise your policy. If today you have an employee already enjoying 666, you finish let them continue. But amend your policy so that the new cases that comes in later is going to be your new term. Maybe 333, maybe 633, maybe 433. It doesn't matter, but you decide. At the end of PIL, after that 1 year period, employee cannot recover. Remember my funnel? You frustrate the contract, or you medical bottom out, it also approves their, approves their pension. So that is at the end of the process. Okay, so now the employee has recovered from a long illness somehow. The performance is not like what it was before. Before he became sick, performance is okay. After he became sick, recovered, performance dropped. Now, his superior knows well they cannot terminate him for another reason or make him resign. We cannot ask him to resign. We cannot terminate him in a friendly way, etc. So how do we manage his case? After a while, he resigned. So in this case, after a while, he resigned because he felt he's not being appreciated, right? He filed the case in IR office. So what happens? Now, let me tell you this. Firstly, if a person walks out, right? If a person walks out, if you terminate, that is unfair dismissal or unfair termination. If the employee walks out on their own, that is constructive dismissal. Now, in the case of constructive dismissal, the burden to prove is on the employee's shoulder. He must prove why he walked out, right? Why he walked out. And if you read on a constructive dismissal, it says this: an employee should only walk out if there is a breach by the employer. And the breach must be so severe that the best solution is to walk out. Now, in this case, not being appreciated, is it a severe breach? Right? That's why you decide. So, yep. Pete Chia, okay, I can't remember, I can't recall, I do not read your name, but I would advise you to read more on what is constructive dismissal. The burden to prove the case is on whose shoulder? In this case, it is going to be on his shoulder if I catch you correctly, because he walked out, right? A person MC during suspension period, half pay, shall be paid MC. Now, this is the first time I'm hearing this question, for the last in the last 20 years of my service, right? A person during suspension, right? If he takes MC, now when the person is suspended, you just disregard the MC, right? He's suspended from work, suspended, right? No annual leave, no public holiday, nothing, only suspension. Okay, no MC all. Tell him MC, you keep it for you. After you come back, you keep the MC. Suspension is suspension. Don't mix these two things up. Right? Same goes to, he said, can I apply annual leave? Suspension is suspension. It's a misconduct. Okay, during P&L, I guess it's prolonged illness leave, when the new year comes. Okay, this is an interesting question. So now what happens is, the employee is on prolonged illness leave. Let's say his prolonged illness leave starts in the month of November, right? And then what happens in January, he's entitled to new set of annual leave. Am I right? New set of hospitalization leave, new set of sick leave, 14 days and 60 days, for example. So what happens with PIL, right? So how do we manage cases like this? Anyone, how do we manage a case like this? Anyone, can you, maybe there's 240 of you all listening in. If anybody can answer this, I will give you the domestic inquiry handbook or the employee handbook or the retirement guidebook or the foreign workers handbook. I give it to you for free. I need one answer. Anyone can answer this question. Be creative. If an employee is on prolonged illness leave, he's on full pay, half pay, no pay, and then he crosses into the new year, he automatically gets new entitlement by law. Okay, let me see. Reset accordingly, for sure, but how do you manage? Because on one hand, he's being paid. Now, on the other hand, he gets new entitlement. How do we manage this? Okay, so I agree, new entitlement, but how? So, because you have a PIL, if you don't have PIL, let's say my company, we don't have PIL, no problem. New year reset, he enjoys back the 14 days and 60 days, no problem, right? But if you're giving PIL, how are you going to manage this situation? Are you going to stop PIL and continue with the sick leave and then resume PIL or what? So, okay. Now, this is what you could do. You can't prorate the sick leave and hospitalization leave. They are entitled from day one, right? Now, what I will do is this. When I design the PIL policy, right? Because PIL policy is your benefit. It is not required by law. So when I design the PIL policy, I will take note of this situation. That is why designing a policy, I know some of you all, I have to congratulate you because you use one of the best technology in the world when it comes to designing a policy. Many of you out there, you use the copy, cut, paste technology. Copy a policy here, some cosmetic touch up, okay, good to go. A good policy, you can copy, you can refer to another policy. But to draft a good policy, you must think of all the possible and plausible scenarios. Possible and plausible. Okay, this is a new word to learn today. Plausible, Plausible. think of all the possible and plausible scenarios and address that in your policy. So a better way to manage this is, if you are in PIL and you get new set entitlement for the year, the PIL will be shrunk, will be offset. That means if you're going to get another 14 days next year, your PIL paid leave will no longer be 3 months, will be 2 months and, 3 months minus 2 weeks. Your PIL paid, the 3 months paid will be shortened to 2.5 months. That's one way to manage this. But if you are generous, you can say that PIL will continue, your entitlement can come after that, right? That's your choice. But I always suggest a very clean-cut approach. If you want to suspend your PIL for a while, continue your sick leave, and then continue PIL, I do not know how you're going to administer this. No system can help you. So either you allow them, let them finish PIL first, and then resume their 14 days entitlement, or you cut short your PIL so that they can resume with this. So that is your choice, how you want to design it. Make sense? Anyone make sense? Okay. So, any other questions? I think I've answered almost all. I hope I've not missed any. There are 2 or 3 not relevant ones. I'm skipping that. But is there any other questions on medical, sick leave, hospitalization leave, and so on? So let me repeat some of the things to take note of, right? As you know, as you think of more questions to ask. Okay, so number 1, if you want to terminate employee because of medical condition, there are few prerequisites, or there are few fundamental things they got to do. Be reasonable, explore all options and actions, exhaust them, find out, inquire, and look into surrounding circumstances. Appoint a specialist doctor to assess them if you can. Now, this is best practices. What I've done in the past, I'm sharing with you how I manage cases like this. And so you can send them for medical assessment. There's a surveillance form, medical surveillance form that we have shared in the forum. Please feel free to download, modify it, set up your PIL policy if you have one. If you don't have one, you may want to consider, but if you cannot, that's fine. But if you have PIL policy, make sure your policy is comprehensive. For example, to capture the scenario where New Year comes, what happens to the new entitlement? So do you offset? Do you carry forward, or do you delay it later? Address it in the policy. In your disciplinary policy, put in a clause saying that failure to attend medical assessment when instructed by company is a misconduct. That is called insubordination. Please spell that out, right? And educate employees on sick leave. Create a culture of discipline. Tell your employees, annual leave, you must apply 3 days ahead, 4 days ahead, based on a company policy, no issues. But if you're on emergency leave or sick leave, right? Yes, you can give us the MC after 48 hours, but please text, please WhatsApp your boss or your superior. Please call or please WhatsApp your superior before the work hour starts. Because at 9 o'clock, you're supposed to be at work. Unless there could be some scenarios, the employee met accident, right? Sometimes, when they're motorbike, they meet accident, sometimes phone goes missing, cannot call. Today we don't even memorize numbers. I don't even know my colleague's number because we don't memorize number, right? You do not know the superior's number. He was bedridden, unconscious for 2 days, and then woke up. These are special cases, which to me is fine, right? These are not your concern. Your concern are people who take advantage, right? So cases like this, maybe the first time, never mind. Second time, never mind. Third time, assessment. See, because you've never taken serious action on them. All you have to do is, hey, Jason, why you never come to work yesterday? Sorry, boss, I was not sick. I was sick. Okay. But if you send them for assessment, make it look serious. Okay, Jason, look here. Company is concerned on your medical condition because too frequently you're on leave, sick leave. We want you to go and see Dr. So-and-so for medical assessment. We will pay for it. If the doctor says Jason is okay, then what I'll do is I will tell Jason, starting next week, you can only go to polyclinic, Mawa, near your house. 24 hours. Don't go for 12 or 24 hours, and we'll only accept MC from MAWA for your case. And what I will do, I will call MAWA clinic. I'll tell clinic MAWA, look here, this employee is on medical surveillance. So if he's feeling not well, please do what you need to do, right? So the doctor will also be very cautious when he comes to clinic. So this is one way to manage employees who abuse sick leave. Because for some employees, they treat sick leave as cuti tahunan tambahan. Right? No more annual leave, apply sick leave. When you give 8 days, tak cukup what? 8 days they got enough. Right? You're stingy on one hand, they take sick leave. Now remember this, when you want to control your annual leave, only give 8 days. What is 8 days today? When you give MC annual leave, if they are on annual leave, you pay them 1 day salary. But when you give minimum annual leave, they start taking sick leave. You're paying for MC, which is, you're paying for the sick leave, which is 1 day salary as well. Plus you're paying for the MC, which is 60, 70 ringgit. So if it's a blue collar employee, operator, or those people at 1,005, annual leave, the cost to company 60 ringgit plus minus. These people, 60 ringgit for the sick leave, 60 ringgit for the cost of medication or cost of treatment. You're paying double. You want to pay 1 or you want to pay 2. So that is why advice to employees always this. Like it or not, there are people in your company is abusing all these privileges. But why do they abuse these privileges? Is it because they're all the bad guys? Sometimes it is not necessarily the bad guys. When you don't give annual leave during probation period. Now, we are human beings. Let me ask you this. There are 227 of you all in the call now, right now. Are you okay if your new employer tells you this, no annual leave for 6 months? Are you okay with that? What happens if your child falls sick? What if your father is falls sick and he needs your help? No annual leave. And people at that level, the blue collar, right, or people at that level, their salary is not much. So when you play hardball, I call it playing hardball. When you play hardball with employees, what they do? Okay, tak apa, no leave, never mind. Kita kan ada cuti tahunan tambahan, we take. You end up paying double. So do you want to pay 60 ringgit or you pay 120 ringgit here? So be reasonable. To me, a reasonable set of annual leave, I know EA gives 8 days. 8 days to me is too little in today's environment. You cannot survive the 8 days. If all of you all can survive the 8 days, 8 days is good. Can you all survive the 8 days? All of you all are listening today. Can you survive the 8 days? I don't think you can. So if you can't, why operator can? Oh, now I know. You guys are human. These are robots and machines. They are human beings as well. They got families. They've got personal needs. So my advice to employees is, please review your practices. You give minimum here, they will take sick leave and hospitalization. Sorry, sick leave. Why they do it? Because you push them to do it. So review these practices. Okay, so let me prolonged illness leave, prolonged medical leave. I mean, to me, keep the process simple, don't complicate it. If you create too many terminologies, prolonged illness leave, prolonged medical leave, illnesses, are they not medical, medical, are they not illnesses, etc. So I would urge you to simplify. Don't complicate things. The more complicated things are, I think when I see you next, your hair will be like me, less hair and white hair, right? Keep the process simple. Don't create too many terminology. We complicate things, right? Keep it simple, lean and fast. Okay, by providing EL, maybe this is the last question. Let me take this last question. By providing annual leave, does it imply automatic confirmation as annual leave is a benefit conferred employee? No, it goes back to policy. If your policy says that annual leave is given to all employees from day one, right, then it does not mean that you're confirmed. But I know where you're coming from, Ellie. But if you give an increment to them, or if you give any other benefits, which is only given to employees who are so-called confirmed. For example, you may have a company policy that says that increment is for confirmed staff, but you give to the probationer. Now, he may be deemed to be a confirmed staff. Or you may have a policy on compassionate leave, marriage leave, right? Marriage leave and compassionate leave is given to employees who are confirmed. But you give it to the employee on probation, now he may be deemed to be confirmed employee. In that scenario, yes. Annual leave scenario, I would say no, but please spell it out clearly in your policy, right? Spell it out clearly in your policy. I think it's a good question that you raised, right? Clearly spell it out in your policy. Okay, so I'm going to end the webinar today, right? So these policies, I'll share these slides in a short while. Maybe in the next 20 minutes, I'll put this up in the forum. Please download it. I will share with you the 2 links for the PIL as well as the medical surveillance form. But please also check out all the other, we got almost 200 forms and policies and templates in the forum, 200 plus. Download as many as you can, make the best use of it. If you find that the policy or the template or forum that you have shared requires some improvement, there's some good things that we do not know that you have, please share with us so we can improvise this and share with all the members, right? And so lastly, I'm going to leave you with this. So if you want to change the game, if you do not want to be always a follower, if you don't want to always be at the end where don't know what to do, every now and then make phone calls, I want to ask this, I want to ask that, WhatsApp group, Facebook group, here and there. Now, that's not the right way to learn. You cannot become an expert by asking questions over the phone, by sending emails, right? WhatsApp, Facebook. It may be free, but when are you going to learn the right way? When are you going to become better? When are you going to become competent? If at the age of 35, 40, 45, we still need this kind of help, trust me, we are asking for trouble. Young employee during their early days of their career, maybe 25, 20, 30, I can understand they're learning. But if you guys are 35, 40, 45, 50, and you're still listening and still need help, still need to ask, still need to WhatsApp, how do I do this, how do I do that? That means we are incompetent. So let's take the first step. Make sacrifices, right? Make sacrifices. Now, when you spend money like this, 15,000, it is not a cost. You are investing, right? I've given you one example just now. If you take 1 week to issue show cause letter and warning letter, I do it in 20 minutes. Now, do you know how much time I've saved for the company? I can start working on succession plan. When is the last time you as HR look into employee succession plan, career planning, open up employees P-file? How long have they been the same job grade? What about competency mapping? Why we can't do it? Because we are busy chasing around people for show cause letter, warning letter, what to do here. That means we don't have a work smart approach. We work hard, but we don't work smart. Now, before you go, write this thing down, right? And ponder. It is easy to work hard, but difficult to work smart. I repeat again, it is easy to work hard, but difficult to work smart. Many people work hard, long hours. I work smart, right? Arul works smart. I'm not saying I don't work hard, but I work smart. So if you can work smart and you work hard, that is a powerful combination. But if you work hard and you don't work smart, forever you're going to be busy, you're going to be frustrated, you're not growing in your career, your boss don't have that faith and trust in you because you don't know what to do. Always ask, how? Okay, let me call and ask. How? Go to WhatsApp. Hey, how? I got problem like this. You're not learning. You're not changing. So make the first step. Make this investment. Change the game. Make yourself competent. And tomorrow, you might be doing webinars like this. So with that, I'm going to end the call today. Thanks for joining us. So I hope this webinar has been useful to you. So our webinar next week is going to be on, if I'm not mistaken, I can't recall what webinar is, but I think it's on definition of wages. So next webinar is on definition of wages. We're going to analyze what is defined as wages, what is not wages, what should be ORP, when should you pay wages, and all those things next week, right? If possible, get your bosses to join this webinar, right? Book your meeting room, open up this webinar, get all your managers to listen, your bosses to listen, and see what is it. They may not trust you because you're insider. Sometimes bosses trust third party better. So let me do the hard work. Let me do all the knocking. Let me do all the drilling, right? If you find that difficult to convince the bosses, let me do the job. Let me knock some sense into them, and I know how to do it. So with that, have a good day. Thank you for joining. You'll get these slides in the next 20 minutes or so. Bye. See you.